Good afternoon, everyone. A very warm welcome to our panel discussion on navigating industrial policy, striking a balance between protectionism, liberalization, development, and legitimate policy objectives in WTO. I'm Kapil Sharma, Professor of International Trade Law at NALSAR University of Law, India. I'll be moderating this exciting and highly enriching session today. We are privileged to have with us a distinguished panel of experts whose work sits at the heart of global trade, industrial policy, and WTO law. Their insight promise to illuminate some of the most complex and timely issues facing the international trading system today. Before I introduce our panelists, let me briefly outline the structure of our session. Each speaker will have 10 minutes to share their views on the respective topics. This will be followed by a second round where each panelist will respond to a specific question with about 8 minutes allotted to each. After this, we will open the floor to the audience for Q&A and interaction. Let me introduce our panelists. Our first speaker is Ambassador Ujal Bhatia, a former member and the chairperson of the WTO appellate body. He served as India's ambassador and a permanent representative to the WTO from 2004 to 2010. A seasoned civil servant, Ambassador Bhatia was previously Joint Secretary in the Ministry of Commerce, where he played a key role in bilateral, regional, and multilateral negotiations, including a chief negotiator for India, Sri Lanka Free Trade Agreement and the South Asian Free Trade Agreement. Our second panelist is Ms. Sangeeta Godbole, a highly respected bureaucrat, academic, and trade environment expert. Our recent work has focused on carbon taxes, free trade agreements, and the trade environment development nexus, especially from the perspective of developing countries. She has negotiated on behalf of India in multiple trade talks, including with the new EFTA and Turkey, and has held leadership positions such as Director General of Service Export Promotion Council and the Principal Commissioner of Income Tax. Our third speaker joining us virtually is Mr. Werner Zdouc. He is a professor at World Trade Institute, University of Bonn, and served as the director of the WTO Appellate Body Secretariat from 2006 to 20. He currently leads the Knowledge and Information Management Division at the WTO, which also oversees the WTO Chairs Program. Mr. Zdouc began his WTO career in the Legal Affairs Division and has since played an important role in both education and outreach. He's also a respected academic, having taught in leading institutions across Europe, Asia, and Latin America. Our fourth panelist is Professor Weihuan Zhou, an authority on international economic law and co-director of China International Business and Economic Law Center at UNSW Sydney. Professor Zhou's research addressed critical and often contentious questions at the intersection of international trade law and China's economic policy. His work is widely published and cited, and he actively consults with the government and businesses on trade remedy and cross-border trade law matters. With those introductions, let me now invite our panelists to present their views. Ambassador Bhatia, may I invite you to speak on the shifting paradigm of global trade, new priorities, old rules, squaring the circle. Over to you, sir.
Thank you. I'd like to address three sets of issues. First is role of the state in global economic paradigm and whether the state can play that role within the guardrails provided by WTO. Secondly, I'd like to talk a bit about green industrial policies. Thirdly, try to address the question of whether RTAs can help in reconciling new industrial policies, WTO disciplines. As far as the first question is concerned, new global priorities, as well as market failures in some sectors, require us to recognize the state has a key role in managing the interface between such compulsions and must also be recognized that substantively WTO rules protect the right of states regulate even ways that restrict trade for reasons they consider to be. So the question is, can states design their interventions, ensure they are consistent with WTO commitments, and have least distortionary outcomes? Based on international experience, some key features of such programs can be listed. Firstly, it is important to predefine key objectives, whether they are strategic interests, national security concerns, or aimed at addressing market failures, as well as metrics to assess their success or failure. Secondly, industrial policy initiatives need to be anchored in larger economic strategies that operate horizontally across relevant economic segments and include measures aimed at boosting innovation, human capital, infrastructure, etc. Thirdly, horizontal measures aimed at boosting innovation, skills, and access to finance are more likely to be efficient than subsidies, import restrictions, and high tariffs. Fourthly, distortionary trade restrictions such as high tariffs, local content requirements, import substitution, and export subsidies need to be avoided, as also discrimination between domestic and foreign producers and farmers. Fifthly, to the extent subsidies are necessary, it is more efficient and less distortionary to provide them for specific purposes, like, for example, preferential financing for green investments and public health interventions, like vaccines. And lastly, as a general consideration, industrial policy initiatives need to be time-bound, transparently implemented, and cost-effective, while limiting negative spillovers to international markets. Move on to the issue of green industrial policies. In recent years, the sector was cited as justifying industrial policy has been the green transition. It is argued that negative environmental externalities and market failures in the sector make a case for state interventions in industrial policy measures to usher in the low carbon economy. Conceptually, of course, carbon pricing is the most desirable option, but politically, there are difficult issues involved also, increasing energy prices, access to green technologies, and the negative impact of green measures on export and revenues. Green industrial policy, therefore, remains the second best but practical alternative. In addition to the considerations I have mentioned, some specific considerations need to be borne in mind as far as green industrial policy is concerned. First, climate change is a global problem requiring global solutions. Green industrial policy is a national response, which nevertheless needs to keep the global context in mind, especially on issues like cross-border spillovers. Second, in economic terms, well-functioning carbon markets offer a better solution than its policy. The policy objective should be work with all. Thirdly, this is for me an important point. China, its head start on green energy, is now the green energy superpower. The large global market share, solar panels, wind turbines, electric vehicles, and batteries. While countries may justifiably consider developing their own green energy initiatives in their national interests, this objective also needs to be balanced with efficiency and cost considerations. In other words, in balance between trade and industrial policy is important. And lastly, given the global consequences of the climate crisis, industrial policy should be as little distortionary as possible in terms of foreign investments, technology transfers, and markets. As far as subsidies are concerned, the SCM agreement does not make a distinction between good subsidies and not so good subsidies. Perhaps it should. One way would be to solve this problem with certain exception rules within the SCM, or perhaps to expand to define Article 8, Article 7, so that while ensuring that these exercises do not in any way undermine the core disciplines of the SCM. The other option, of course, would be to make Article 20 of GAN applicable in this. In the absence of the other body has tried its own efforts this direction. Canada fit case, it distinguished between electricity markets and conventional. Not a very elegant solution, but we are dealing with segments. Let's move on to the issue of RPS. Trade show production based on strategic or national security concerns raises several questions regarding viability and compatibility with WTO disciplines, especially when defend and national freedom principles are organized. Global value chains are built around a strong economic chain and advantage, and it is neither easy nor cost effective to build ecosystems of suppliers in single jurisdictions. RTAs which are compliant with GATT provide a reasonable middle ground. Regional supply chains that emerge from RTAs have several advantages: lower transportation costs, integrated tariff structures, common investment rules, etc. The preferential rules of origin may facilitate greater local content of participating countries and provide more economic security, supply chain resilience, while at the same time reducing risk of violation of WTO disciplines. So let me conclude by saying that overall, in view of global priorities, states have a more dominant role to play in industrial policy. A major issue in this regard is that existing WTO rules are not always adequate to justify action under. So obviously puts a greater burden on adjudicators. In most such disputes, respondents invoke the exception provisions under the GATT. In the long run, in my personal view, this is not a sustainable situation. Why
Thank you, Mr. Bhatia. May I now invite Ms. Sangeeta Godbole to share your insights on flexibilities under the WTO for carbon, water taxes, as developmental, industrial policy, and climate action plans. Over to you.
I'm really honored to be here. This panel, I'm a lawyer. I've been a trade negotiator and a taxman. So I have negotiated in the EU, as a from the Indian side, and as you see my presentation, you realize most of it emerges from that experience, and then it research. So what I'll do today is to look at the flexibilities and developmental for carbon border adjustment, what were available, and then look at carbon border adjustments as industrial policy tool, as development aspirational tool, and as climate action tools. So that is how I want to go on my session. And mostly with specific reference to India, because India is the biggest component of CBAM. It is the largest, not the largest yet, but it is soon going to be the largest emitter, and then interesting for some of you to get what India is doing right now. So well, since we are amongst a bunch of very, very learned and experienced lawyers, I have just listed out how carbon border adjustments find flexibility under WTO law. I don't propose to discuss it because right now it is all in flux. We don't know whether we are here or there. There is one challenge to it. What will eventually pan out in the panel or in the appellate body, no one knows. Is it going to be legal? Is it going to be illegal? Don't know. On top of that, just on 2nd July, the climate commissioner, okay, whatever. So he just declared that the EU will provide subsidies to EU's exporters out of CBAM revenues. So that has become strong, and so I have also heard at this conference that even if border carbon adjustments and particularly CBAM don't really comply with any of the MFN or national treatment or restrictions or whatever, it can still go to Article 20 exceptions, and hopefully it will clear through that. It's not even sat on it, so it's still really has to be up. So if we keep this matter aside and let time takes us, I would like to go to the next. So CBAM has been positioned as a tool to plug carbon leakage. By carbon leakage, everybody understands that industry going away from the European Union elsewhere, because you can still leak carbon in a sense, or you can still emit carbon outside the EU. The laws are lax, etc., etc. And therefore, EU has squarely positioned CBAM as a climate action. EU industry pays high carbon prices. It is between 70, 60, 80, something like that. I just put the Indian conversion. So 1 ton of carbon, which might cost 70 euros, in EU would cost 7,029 for an Indian MSM. This has to be. Now the question was, why shouldn't the others pay? Why should only EU industry pay? And why should other manufacturers benefit from greater competitiveness that arises out of not paying the border carbon fees? And therefore, global industry must pay the same price and EU borders to access new markets. It's fine till there. But now, and I have listened to a number of industry people speaking at various webinars. Now, the problem is that if you are going to implement such high fees on carbon emissions at your border, your inputs are going to be substantially expensive. And the EU industry, particularly steel and aluminum, is now realizing that they've driven out of export markets. And export markets are critical to survival of the EU industry. And talk has been in several webinars that I have heard, specifically with the industry, of deindustrialization of EU. We are not talking about losing jobs or carbon leakage or whatever. It's clear that deindustrialization of EU because of very high carbon fees on steel, and then also the downstream industry. So enter the commission, and then I said that declared commissioner has already declared on 2nd July that he would subsidize 70 billion euros in 2026 to its exporters out of revenues earned from CBAM. Now, this goes from being a climate action tool to an industrial policy tool, and I'm sure many in the developing countries who will export to EU, who do export to EU, will raise questions of whether it is reverse climate finance. It is CBAM fees because it is going to be a buyer's market, so China will compete with India, will compete with Kenya, will compete with Egypt, and one of them will pay fees and get access to the EU market, and then the same CBAM fees will they be used to subsidize EU exports back again to India. So the other question also could be asked is whether will EU industry then produce emissions heavy steel? Because anyway, for export purposes, it is going to be compensated. So these are the questions that will arise as we go along. Details are not yet out. I'm sure with a well thought out scheme, just like we did. The next, so CBAM goes from being a climate action tool to an industrial policy tool, and then there are years of reverse financing of carbon emissions from the south to the. Alright, now what is happening in India at this point in time? I just wanted to bring to everybody's notice a scheme which is not much discussed. It is called PAT, Perform, Achieve, and Trade. And it fits so packed with CBAM that I thought maybe let me talk about PAT today. So PAT has been active or has been implemented since 2012, and it is a baseline and credit scheme so that for all those sectors that are, or it's too small, perhaps too small. So the sectors are cement, commercial buildings, iron and steel, petroleum, refinery, pulp and paper. All the high emissions intensity industry in India have to abide by certain energy efficiency targets. So it is different from allowances. For example, it has not been mentioned before, but much of the emissions reduction after decades has arisen out of lowered manufacturing. So you get a certain number of allowances, you don't manufacture, you don't emit, and therefore you use those allowances. So in this case, in India's case, it's a smartly designed scheme. It is about per unit of production, energy efficiency per unit of production targets, and it is not in absolute numbers. Since Indian energy, largely thermal, has a very high carbon conversion factor, this automatically becomes an emission reduction scheme. So Indian industry in all these sectors has been consistently reducing energy consumption and also emissions for all these years. This is a pure wired environmental action. It's smart because it is based on energy efficiency and not on fixed number of allowances, A, and B, it focuses on energy efficiency, which can motivate business. If you ask Indian MSMEs that there's some carbon going into the atmosphere, we need to stop it, they will say, okay, we can see tomorrow. But if it is about energy efficiency, it motivates business because there is going to be savings and greater profits out of energy efficiency. So I think it's a very smart scheme that is going on. It also dovetails very well with India's NDCs because Indian NDCs are about emissions intensity of its GDP. Therefore, the lower the emissions intensity, the greater the possibility of development, of lowering poverty, of higher per capita incomes, etc. So, the current Indian price of, so as per the scheme, there is a certain target given to you for energy efficiency. If you achieve that target and if you do better, you get a bunch of energy saving certificates which can be traded. Right? So currently, if you don't perform as per the targets, then you have to buy energy saving certificates. Currently, the price of the certs is about 2165. And with a conversion factor about 3.5 to 4 tons of carbon, the price is around is 500 to 700 per ton of carbon emissions. So we compare it with the EU price of about 7,000 rupees, 700 rupees. It's a 10 ton, it's a 10 times differential with the current carbon prices in India and all this has been chugging along for some time. Of course, it is not a perfect scheme. Many civil organizations are saying, oh, you're not stringent enough, your targets are not good, you're not punitive enough, please raise the price of carbon, etc., etc. But still, the scheme is chugging along. And the CBAM and the Brussels effect and the same Bureau of Energy Efficiency of India, which has been implementing this Paris scheme, is now experimenting on an Indian carbon market. So it's not suitable to the Indian conditions, the carbon market, because in India there are only a few designated customers. So the government has picked and chosen, okay, you are the ones who will have the energy efficiency targets, the others won't. But if the others are going to export to the EU, they now with the carbon market, they also have to come under the carbon market scheme. So the focus on an India-specific suitable mechanism is now lost. The bureaucratic, burdensome, and forcibly introduced carbon factor calculations. No one has the time to predict if the emissions are reduced. You just factor in the carbon, make the calculations, and all these up. And any sustainable carbon price in India, I said it's right now 700 rupees. If the EU carbon price is 7,000 rupees, that is 10 times. Any sustainable carbon price paid by the makes no difference. They will again end up paying a huge amount at the borders on carbon, because it's all about what is being paid. It's not about the carbon emission. Plus, it has little effect on the actual emission reduction. Many said for CBAM is not going to really make great effect on the emission reduction. So, on the developmental policy space, pathways, and mechanisms, in third countries, CBAM does not go well. It may well be WTI, but it limits the policy choices, it diverts the energy priorities of countries, and so on and so forth. So, on space, this is what I have to say. And finally, on climate action, under the Paris Agreement, prime instrument of the current climate action, there is no mandate to act beyond jurisdiction. That's my understanding of it. Article 4.18 talks of regional economic integration organizations such as the European Union, but action is foreseen only in jurisdictional borders. Unlike WTO, Paris is more about cooperative mechanisms, about it is not about transactional market access and profit-based motives. But when we bring in a WTO compliant climate action, the result that doesn't go well. And on the climate action front, it changes the priorities, NDC, the nationally determined contribution, which is the bedrock of current climate action. It changes the pathways, it changes the priorities, it impinges on the pathways and also impinges on the CBDRRC. So from the common but differentiated responsibility and respective principle, which is so dear to developing countries, to historical emissions and seven countries. India, for example, is focused on biomass, on solar, on green hydrogen, on wind, on so many things which are so suitable to the Indian climatic conditions. And then you just suddenly have to start measuring carbon on particular sectors of industrial, of the choice of the EU, not the choice of India. I think it doesn't really comply either with the NDC principle or with the CBDRR principle. As a climate action tool, therefore, in my understanding, although CBAM is the prime and carefully thought out instance of a border carbon adjustment, it is violative of climate action instruments negotiated. It can hinder ongoing climate action in other parties' jurisdiction and have little effect on overall emissions reduction.
Thank you, Sangeeta. Professor Werner, may I invite you to speak on WTO law and industrial policy, constraints, policy space, and the evolving regulatory landscape. Over to you, Werner.
Thank you very much. Thank you for organizing this panel, and thanks for the organizers in Taipei for making the participation, which unfortunately has to be for some family emergencies, online possible. I'm going to focus. Am I well audible? Is this okay? Is it okay for the connection? Hello? Is it working?
Yes, your sound is, we can hear your sound.
Okay, so I can carry on. So I'm going to focus on 4 topics. The last one, though, in terms of policy advice for developing and least developed countries, I will focus on probably the second round. So what are the key developments of IP currently? We have already heard it's back center stage as an accepted part of economic planning, but nowadays framed by climate change, economic resilience, and geopolitics. IP has evolved from expert-led to innovation-based, and nowadays to soft power-driven, where cultural, political, and social influence are key in fostering cooperation and creating favorable conditions. Countries have been shifting from market correcting to market shaping IP approaches. Climate-related IP remains important, but is losing momentum. Evidence of deceleration and headwinds for economic transition. Also, public funding is slowing down. There's a shift to public policy towards desires for economic resilience and energy sovereignty. There's a stronger focus on post-pandemic resilience of supply chains and supply chain connectivity. The growing geopolitical fragmentation is a consequence of reshoring and friendshoring amidst mounting tensions. We're also faced by growing private sector reluctance because of structural and regulatory uncertainties, along with insufficient alignment of international rules with contemporary challenges. As it was already mentioned, that regional integration offers a potential for IP and enhanced regional cooperation as a way to build scale and attract green investment. There's also, one can also witness a rise in regional competition law enforcement to tackle tensions between fair global trade rules and in order to avoid subsidy races. The key challenges for IP are financing, human capacity, and WTO rule constraints, and we'll take them in turns. The post-pandemic era sees a rise in the cost of capital since 2020. Geostrategic risks of policy reversal and policy turmoil, prices of different forms of energy traded across borders are increasingly volatile. Economies are falling behind in regulation practices and production markets. Limited domestic market size and fiscal space are key challenges. All this leads to an inability to attract private investment absent significant incentives. Subsidies seem to be an answer, but they often fail to improve productivity, casting doubt on their long-term value. It's also important to define what success of IP means. What are carbon efficiency metrics useful to judge policy performance? What is effective and what is wasteful support? Another problem faced, especially in developing countries, is poor data quality and timeliness of data, as well as inconsistency of definitions that may lead to misguided policies. Key sectors, some of them already been mentioned, green technology, transition technologies, decarbonization, also critical minerals and raw materials processing within countries with such endowments, digitalization and digital infrastructure, semiconductors, agriculture and agricultural industries, services offering great opportunities for developing and least developed countries, post-pandemic supply chain resilience, and in all of this, there should be an increased role for the private sector and private-public partnerships. So we're faced with key policy priorities framed by climate change mitigation, nevertheless still, economic resilience and geopolitics, and the need to balance climate ambition with the WTO rulebook, global fairness and economic autonomy. Challenges of physical and digital infrastructure, servicization, private sector collaboration, and managing and deflating, if possible, growing geostrategic tensions. Against this backdrop, I'm going to go through a host of WTO rules and challenges and where there is a need to adapt these rules. It has been also often criticized from a developing country perspective that WTO rules and disciplines are obstacles to industrial policies, but I would argue that they should not be first and foremost be seen as obstacles, but giving positive economic policy guidance that will render IP more targeted and effective, and they will avoid regulatory capture and rent-seeking behavior by protected industries or upstream and downstream suppliers or downstream processors. WTO rules and principles foster the use of most efficient trade policy instruments. Horizontal IP measures are less likely going to cause trouble in legal terms than vertical IPs, meaning sector-specific measures and policies. For example, well-designed R&D measures, subsidies or tax breaks that are horizontal are proven to be effective and less prone to challenge from a WTO law perspective. There's a strong need for coherence with competition law, investment law, intellectual property law, and policy. If there is a choice between demand-side and supply-side IP measures, supply-side IP measures are more likely to trigger WTO legal concerns than demand-side measures. Production subsidies are usually legal and most efficient in terms of the ranking of trade policy instruments. Export subsidies are not and thus prohibited. Quantitative import and export restrictions are inconsistent. Import and export tariffs are usually not inconsistent. This depends on tariff bindings and export tariff commitments where they exist in accession protocols. WTO non-discrimination principles apply. In the previous panel, we already heard local content rules may sometimes be necessary to pass climate change measures in Parliament, but dispute settlement practice, as mentioned by Ujal, has sort of separated them from the positive policy aspects and declared them illegal. They are violative of WTO principles, and they are often unnecessary for the achievement of legitimate policy purposes. However, where IP is meant to build up domestic production capacity, substitution of imports is intended, which does not easily fit into the conditions of exceptions in the WTO law, such as GATT Article 20G, where restrictions on domestic consumption and production are also required. By contrast, export requirements, for example, an investor company incentivized with investment preferences, are not GATT illegal. Only import-export balancing requirements are prohibited. Industrial policies could be justified under WTO exceptions, where they fit under the catalog of 20 or the national security exceptions. For green and climate change, we've talked about we and she and the chapeau, which is the area where the CBAM that was discussed already would probably face scrutiny and need for adjustments. For health-related IPs, for example, post-pandemic resilience in supply chains, also 20B or the TRIPS Article 7 and 8 could be relevant. Where it comes to local production for products in local short supply, Article 20J could be relevant. There's the India solar panel case. But not only domestic production, also imports where the actual potential must be taken into account. On the other hand, it could be argued that imports are not reasonably available if their price is much higher than domestic short supply, and thus such imports would not actually be capable of filling the gap between demand and supply. For arms and defense-related IPs, Article 21, 14Bs, 73 TRIPS have been mentioned. The real challenge here are dual-use products. The potential reach of Article 21B2 has been mentioned yesterday in this conference already as potentially almost as important for dual-use products. Then there's the renewed relevance maybe of infant industry protection, the classic Article 18B and C. The theory track record of being a successful and effective means of building up domestic industries, though, is mitigated at best. Many developing countries abandoned on their own volition using this option under the GATT. Why is that so? The provision is broad in reach. It would allow for price-based and quantitative restrictions, contrary to the ranking of most efficient trade policy instruments. But there is usually no explicit time limit to that provision, and that was exactly the part of the problem. The domestic industry protected behind tariff or quota wars has no incentive, no pressure to become competitive, to face export competition, unless its economies of scale and scope and its innovative capacity is such that it can compete on world markets abroad, where it naturally must compete facing world market prices, therefore fostering more efficient production. So even if not required under the current WTO law, countries using 2018 for IP purposes would be well advised to make such protection time-bound and digressive with a progressive phase-out of such protection. However, real 21st century problems with infant industry protection is that the belief of this provision is import substitution of entire industries. This is ill-equipped to transnational supply chains where countries specialize in raw materials or inputs or intermediate goods, and nowadays in certain tasks, often of a services nature, within supply chains. Thus, the infant industry model is shielding of domestic markets from foreign competition, does not seem adapted to these new realities of production chains and intercorporate trade. Where infant industry protection is meant to target export markets, they often need to be accompanied with subsidization. Finally, I turn to the subsidies agreement. The key obstacles, and these disciplines have often been criticized as a key obstacle to IP. It's true that classic WTO subsidy disciplines are narrowly focused through an economic lens. Strict enforcement appears outdated. Nevertheless, the disciplines remain useful to avoid subsidy races and rule setting by the powerful with deep pockets. The alternative to multilateral subsidy standard setting seems to be norm setting unilaterally, as we have seen with CBAM. It's common wisdom that the SCMA is ill-equipped to accommodate development and climate-oriented subsidies. Many subsidies, though, pursue a broader economic, public interest and strategic goals. What the toolbox needs to do is to distinguish better between legitimate green subsidies from protectionism. For IP in agro-industry, also the subsidy rules of the agriculture agreement would be relevant. Turning finally to Article 8 of the subsidies agreement. So there needs to be more policy space for green and developmental subsidies. and re-acknowledgement of green and developmental goals of this expired provision. Developed countries already assert policy space. Developing countries need to be given the opportunity. But reviving the expired provisions will not do the job, because there is a need to distinguish between subsidies correcting environmental failures and green transformation and subsidies driven by industrial competitiveness and supply chain resilience. So the green subsidies from the expired chapter are, there are three main ones. One, exemption for research and development subsidies. Interestingly enough, footnote 26 to the SMA already totally exempts fundamental research subsidies, which could be relevant in this context. Exemption of rural development subsidies for disadvantaged reasons, but the most important one is about adaptation of existing production facilities to new environmental standards. Why not also the creation of new facilities? Why not also the adaptation of facilities to existing environmental standards? Why is there a threshold of 20%? Why only one-time non-recurring? All these conditions are ill-equipped for the current challenges. What is positive in the existing rulebook is non-discrimination, in the sense that green subsidies need to be made available to all similarly situated companies to avoid distortion in domestic markets. Strengthening multilateral permissions and conditionalities would reduce the need and the likelihood of punitive responses to climate-aligned subsidies and unilateral tools, as we have heard by the previous speaker. Improved transparency is important. Modernized conditionalities, because limitless policy space is may likely lead to rent seeking and subsidy capture by favored industries, also upstream and downstream. I leave for time reasons aside the special issue of special economic zones, and I will return later to the question of priorities from the perspective of developing countries and LDCs. Thank you very much.
Thanks, Werner. We now invite Professor Zhou. So please take the floor to speak on digital industrial policy through data security, China's approach security and trade agreements. Over to you, sir.
Thank you. It's a great panel. I'm presenting on behalf of my co-author, the students, and she would be mentioned today. Now, I think within the time I have, I want to just give a very broad overview of what we're doing this project, which we believe, as we observe, is kind of an under-researched area. And the reason why it is under-researched is because that we all have focused on many of the individual issues, but overlooks the interaction between these issues. Let me just explain a little bit more. There are at least 4 defining challenges that I think my fellow panelists have mentioned already. The one is the global race for industry policy. Second is the expansive use of attributes of national security. And third is the rise, of course, the ongoing challenge from geopolitics. And the final one is actually a related question about the paradigm shift from a focus on economic gains to non-economic issues, which is leading to governments turning inward from international cooperation. So those are the individual defining challenges that I think we're all facing today, and we all recognize their existence as a given. So the question for us in this project is how they interact, and in particular the question of how governments may or have already been using national security for industry policy objectives. So it's that kind of linkage between industry policy and national security that we want to explore in this case study. This case study, because it's very, very difficult to explore this issue, I take a very broad view. So it's a reasonable, I think, for us and useful for us to look into a sector that is at the forefront of the current debates of industry policy within what we call the digital industry policy. We talked about environmental green industry policy. That is part of the green transition. This is the second half of the dual transition, if you like, digital transition that's happening everywhere. So the question is how national security has been used or may be used for digital industry policy, which means by class definition, using national securities for the domestic digital sectors. And now we use China as a case study by focusing on China's data security and data regulation. And the question, so the more specific question is to look at how China may have used or may have the potential to use national security to support data sector. Now, of course, when we're speaking on this issue with a case study, it has a broader implication for the global trading system. And the reason is because that goes into the classic question that I think we also discussed yesterday about the balancing act between trade and national values and how you rethink current existing rules in the WTO, in FTAs, to discuss whether a proper balance has been achieved. And if not, how we achieve it? And that's the question I think that we're going to today. So I will get to it, and depending on the time we have. The challenge we are facing is why there is a risk for national security being abused. The ambit of national security is claimed to be within a small yard, protected by high fences. But the fact of the matter is, it extends far beyond a small yard and protected by higher and higher fences. So that is the potential risk that we're facing expansive use of national security for all sorts of objectives, including industry policy. If you look at the strategic competition between the global powers and the geopolitical tensions, everything can now be characterized as national security. And of course, data security is national security. Security can be national security. Energy security can be national security. Critical mineral security can be national security. Everything can be national security. So this creates the loophole that national security may be abused for industry policy purposes. Now, I don't have time to expand on China's data regulation and security laws, but let me just be very brief. No one would be surprised to know that China has developed a very robust industry policy in the data sector. There's no surprise. But I think that the really nuanced way to look at it and to ask the question whether China has actually used national security for industry policy to support its data sector. The approach China has been taken in terms of data industry policy is to really support the full supply chains, from innovation to creation of data, collection of data, and storage. So all sorts of areas that data relates is protected and supported. Now, that doesn't really answer the question of whether national security has been used for that purpose. Also, in other words, whether China's national data security law and the implementation has been used for industry policy. Now, the short answer we found is that there is no compelling evidence to show an abuse of national security for data industry policy under China's current practice. The law does not prohibit cross-border transfer of data, does not require absolutely localization of data. So there are criteria in which companies could apply for security review for the data to go overseas. There is criteria for companies to say that we don't want to localize data, right? And the current approach is based on risks and based on what several categories of definitions, including mainly critical information infrastructure operators. So all the data or collects used by these operators will be required to be localized. Important data, I'll come back to it, not specified in the law, and personal information beyond certain thresholds. So those criteria also apply to the requirements for security review for cross-border data sources. Now, look at the face of the law, and the regime is balanced and not really trying to restrict the transfer of data across the border or require localization. And there are some facts into it. For example, the European Chamber report in 2023, 70% of European firms can transfer data outside of China without a security review. And it's reported by the China authority in 2024, only around 10% of notified projects filed the security review. There are other evidence in the reports and other reports and from official and non-official sources. But another important factor to realize and to know is that China has been trying to further streamline, clarify the process. So, for example, they have provided templates for the security reviews, have also provided guidance on how many days that the security review will be assessed. Importantly, allowing different free trade zones to create a negative list of important data, directing specific sectors to come up with their own list of important data. So we're still in the process. Now, of course, before the process is completed and clean, there will be certain kind of restrictions or barriers to data transfer and localization, but I think we're going down a right path. Now, the potential, so still, why is the potential risk? There are at least two reasons. First, I will finish after that. The first is that the definition of critical infrastructure operators are too broad. The second is that we're still lacking a very clear and narrowly defined category of important data. And we are also facing the regulatory fragmentation between different sectors. So those are the one of the issues we're facing. The second issue, which is related, is about the land transparency process. We never know. We only know the outcomes, numbers. We never know what was reviewed and why the decision was made in a particular way. So if you combine these two factors, you look at China's retaliation, for example, against the United States, by restricting critical minerals exports based on national security, we are facing the risk where there is a potential for China to use the existing law by discretion for industry policy purposes. So the next question, I guess, is, do we have sufficient international trade rules and exceptions to accommodate a balancing act? Right? So I think that's perhaps something we can talk about next.
Inviting each panelist to respond to a focused question based on their expertise and earlier remarks. Ambassador Bhatia, as we have seen last couple of days with the discussion going around that industrial policy can be challenged, and like if it is challenged, the rescue is Article 20 and 21 of it. Now, what do you think that whether it's a WTO dispute settlement system is equipped to adjudicate disputes involving industrial policy measures, and what kind of challenges might it face in doing so?
Thank you. Let me touch briefly on these two provisions of 20 and 21. For Article 20, I think there is not much to say, except that the jurisprudence around invocations of Article 20 is pretty well developed, especially rapid body units. Werner has also mentioned particular subparagraphs which can be potentially invoked when disputes arise against certain industrial policy measures, green measures. The appellate body has developed pretty good guidelines about how arbitrariness and protectionist abuse are to be dealt with in the dispute process. The security exception under GATT 21 is, of course, another technique. This is something which is a very recent development. And the jurisprudence of this is not well developed at all, except that we have certain clear findings from initially from the panel in Russia traffic and transit, which is an adopted panel regarding the arguments of self-judgment as well as on the issue of justiciability and jurisdiction. Problem now is political. Because the United States, for instance, questions this issue of non-justiciability. And even though there is a adopted ruling, and therefore, I think the problem is not so much adjudicated. It is a political problem, which requires dialogue with the developmental members. But in the months and years to come, absent such a dialogue, I think there are going to be a number of disputes in the WTO invoking these provisions. And the adjudicators will do what they have to. But the consequences of those rulings, especially to the extent they relate to the United States, may be very challenging, and there may be issues of compliance. So I think we are in this protected system faces a difficult challenge in this, but this is not for the dispute system to address. It is a political issue meant for the WTO members, and I hope.
Thank you, Mr. Bhatia. I just have one more question related to this. Like, as pointed out by Werner and you also, that we are not left with option Article 20. The only option left is Article 21. So, what this will going to mean is that in each and every case, like if US, European Union, or any other country who has industrial policy and they want to defend it, the only option left with them is only Article 21.
Well, I don't think that's true. I think the bulk of the defenses will come in Article 20. But the question is, as far as, for instance, the United States is concerned, many of these actions are taken under Section 232, which corresponds to the security exception. And therefore, when the matter comes to the WTO, there will be invoking the security exception. And there the problem which I have mentioned.
Thank you, Mr. Bhatia. Now, may I invite Ms. Sangeeta Godbole. Ma'am, as you have already pointed out, the consequences of SIEL on India. Like, to go further on this particular point, what do you think that on the background on the divergence on the border carbon adjustments and particularly SIEL, what could be the way forward about it?
Just yesterday, has issued a very, very strongly worded statement on CBAM. They have said we condemn it, we reject it, it is extraterritorial, it is punitive, it is everything that I have not seen such a strong statement from the entire BRICS, and now BRICS is bigger than just BRICS, right? It's about 13 to 14. So we don't know from where will CBAM go, either politically, will there be applicable political solution to it, or do we have to wait for WTO jurisprudence, which may take a long time, and then again appeal, avoid, etc. So we don't really know where it could go. But I was just imagining if the EU had said that as much CBAM fees as developing countries pays at the EU borders, we will match it with our contribution and contribute to that country's decarbonization efforts. I think the whole texture and character of this tool, of this measure, would have just completely flipped and changed, and there would never have been this kind of confrontation and constant criticism of such a tool. So these kind of sensitive, cooperative approaches, and effective. You raise a carbon border tax and the entire world is fighting against it, and you just on trying to defend it here. And in the end, it doesn't even help the emissions reduction objective. It's one way of going about. The other way, it could be something like this, which is not so difficult at all. And this could have really revolutionized climate action, I feel. But I don't, this will not be so. I think what we need is sensitive, cooperative approaches and collaboration.
Want to respond to Sangeeta ma'am's remark? Please feel free to.
Yeah, just somebody named our life or name it that this is the all great. But there are strays or straws in the wind. The political movements will make their very own statements. At the end of the day, it's what they discuss at the negotiating table which matters. Now, yesterday I was told that in the ongoing negotiations with the European Union, India is maybe talking about some sort of a transition period for NSA needs. That's maybe one step forward. So I'm on a parallel track. Large exporters of India do business with the European Union are preparing themselves to DC and comply. So at the end of the day, how this works out, whether the European Union will take the type of step or not, we don't know. But I think the matters will evolve over the next few months.
Professor Werner. Am I audible? Professor Werner, can you please
Yes.
answer, like you have already explained about the industrial policy and the various regulations of WTO. Now, can you please also discuss on this point, like while international legal and policy reform, why international legal and policy reform should be prioritized in order to make industrial policy work for developing countries and least developed countries?
Sure. Thank you very much. Yeah, I think this is key, of course, because the big players, as we've heard from other statements, they are unilaterally moving forward. From a perspective of developing countries, it will be important. There's a need for policy space, coordination, coherence, and also domestic and international institutional alignment. Now, the classic legacy sectors like steel, cement, aluminum, chemicals, mineral extraction, domestic processing of raw materials, they still offer significant but ultimately limited developmental potential. I would say export restrictions and export tariffs may be justifiable under the conditions we mentioned and Ujal has mentioned. But ultimately, once you have transitioned from a purely raw material society economic system to a more developed system, this potential fades away. But it's not to say that there are not still opportunities for IP and for creating demand through raw materials processing and domestic value added. So although they are carbon intensive and politically sensitive, these sectors remain key in green transformation. They are also technology incentive, and do these developing countries still have insufficient access at affordable terms? Now, there's of course an additional struggle with limited market size and economies of scale. And one way out, I think, was also mentioned by Ujal, is probably regional IP policies to overcome these constraints. Also key for developing countries will be effective governance, transparency, and clear metrics to measure success. Also in this respect, WTO law wouldn't impose any restrictions. Rather, this would be probably helpful in justifying IP policies under various disciplines, exceptions, and so on. So however, and it would go against, it would avoid funding waste and through subsidy races. Now, IP needs when it comes to climate change issues, needs to focus on a nature first lens and an inclusive reform. But we face the linkage of now green and strategic IP, as exemplified by the EU renaming of the Green Deal to the EU Clean Industrial Deal. There's also potential for developing countries in recycling, reuse, and circular economy life cycle analysis and approaches. And I think when it comes to climate change, national determined contributions, many have criticized the obsession of the EU with carbon pricing and carbon emissions, when in fact many other forms of national determined contributions would be also available and should be accounted for when it comes to developing countries. Now, we have inequities in fiscal space, and there's a risk that there's a two-tiered system where countries with more legal and financial capacity can test the boundaries of the trade rules more aggressively. So therefore, especially for developing countries and least developed countries, access to finance remains key. Otherwise, the global south risks being a rule taker in the subsidy game that is tilted towards major developing countries with deep pockets. But developing countries could also focus on low-cost, innovation-based and soft power IPs. Obviously, not one size fits all. And there's need for, as I mentioned at the outset, multi-agency alignment, private sector involvement, and public-private partnerships. The risks of IP for developing countries is also that through investment incentives, foreign firms may outcompete domestic producers and distort global prices. So there is always a need to look at the reverse discrimination of domestic producers when IP is meant to attract investment. Now, there are two areas where for developing countries this is particularly important to focus on. These are green technologies and to overcome the digital divide. So the focus on services and digitalizations are vital dimensions for developing countries to shape their competitiveness and to acquire future comparative advantage. And this goes hand in hand with the advantage that in these areas there's broader policy space, because GATS covers mostly only service sectors and modes of supply that were liberalized, and this was done less so by developing countries. And also the digital trade agreement of the WTO is still in draft form, and it doesn't tackle some of the most crucial elements in regulating digitalization, where, as Ujal said, rightfully so, the rulemaking happens at regional levels. So the emphasis of servicization would also, digital infrastructure is of course also a way to develop provide infrastructure for many other sectors in investment, focus on skills and education. And when it comes to services, they're often less capital intensive. They require smaller scale for global competitiveness, and they often have a lesser carbon footprint. So servicization and climate change mitigation would go hand in hand. Of course, there are notable exceptions in service sectors like tourism, transport, or certain IT services. But important is universal logistical and digital connectivity to develop a digital ecosystem. Now, two last points on agriculture. Again, this is an IP area for developing countries of higher interest, focus on biofuels, bioplastics, and sustainable inputs. That remains highly protectionist in many developed countries. So agricultural IP would need to be multifunctional, focusing on food security, food safety, farmer income support, rural incomes more generally, structural transformation, green value chains, but also cultural values, protection of indigenous people in formal sector. So these are all avenues to reach sustainability, inclusiveness, and resilience. As we know, agriculture is a major carbon emitter, but also highly vulnerable to climate change. Finally, two other areas for developing countries. It's important to be very active and participating in standard setting and certification to avoid protectionist abuse of such standards being tilted against developing countries and their IPs. And another area is green public procurement that can generate demand in green and new IP sectors. Again, here there's more policy space for developing countries because they mostly haven't signed up to the WTO Government Procurement Code 1 and 2. And as a final point, as was mentioned, the use of Article 21 for rather economic and security than national security. I cannot see a way out of this if there is not more discipline and more review of conditionalities. And except for the US, I think many other countries do realize the more geostrategy and national security stretch to economic security, there's need for there is absolutely need for more strings attached to it. And then finally, a last word on least developed countries. The studies I've looked at surprisingly didn't prioritize access to capital, but policy coordination, the need for tackling weak institutions and coordinating, aligning different policies domestically. The need for strategic tailoring, but also the need for participating in standard setting and ultimately access to capital, focusing on job creation, energy access, technology transfer, and maybe also global funding mechanisms, access like with the trade facilitation agreement for least developed countries would assume more obligations in climate clubs or plurilateral sustainability agreements, or to cope with unilateral mechanisms if they are funded properly, and taking CBAMs as a final point, also participating and benefit from recycling and revenue sharing. Thank you.
Thanks, Werner. I invite Professor Zhou. Professor Zhou, please answer what you think. Do the security exceptions, development trade agreements provide an effective balancing mechanism between data liberalization and national security interests?
Thank you. Imagine that the US and China in the race to be the leader of AI technologies models. Data becomes increasingly important, and therefore they're trying to put more restrictive players on data based on national security. This is part of the economic security for the country. And that becomes a real issue for the trading system, right? Now, there is, of course, the question of whether GATT or GATS actually apply to data. Assuming that applies, then the question is whether the national security exception and other exceptions in the existing agreements provides room for striking a proper balance. Now, the current jurisprudence on national security wouldn't help because the interpretation of emergency is very restrictive. So I won't go back to that whole jurisprudence, but it's so restrictive that it would not really provide a proper space for regulation, data regulation based on security. However, if you look at Article 21A, which says, which provides considerable leeway, in my view, for government to refrain from providing any information because of the disclosure will be considered to be against national security. Now, of course, the question of what information means, does it include data? So those are kind of threshold questions needs to be defined and decided. But at least that it's a separate paragraph. It's not subject to the subparagraphs under Article 21B. And so there's legal confusions there. And the only requirement, perhaps, is what we call the minimum requirement of plausibility, right? So that means this is still not going to be self-judging, but it's not subject to so much legal constraints in that perspective. Now, would that be applicable? We don't know. I mean, there is no case yet, and discussion has been limited in the literature. But I think there is a view that provides at least some flexibility. If you look at the recent developments in treaty agreements, so for example, the CPTPP, UNSW, DEPA, they actually went to the other extreme by expansively liberalizing the flexibility, right? To actually more flexibility for government. At least three approaches. The first one is to say that it's not limited to the disclosure information, but also includes providing access or allowing access, which could be interpreted as an inaction. So if you do not do anything to restrict access to information, that also can amount to a cross-border supply of information. The second one is to remove the subparagraphs, so legal conditions are in 21, which essentially leaves only the plausibility requirements there, which, as we know, is kind of a remote connection between the means and the ends. And finally, for example, passive digital trade rules are not subject to dispute. So there are three different approaches taken in some of the most known advanced agreements that provides more advanced rules for data liberalization, compensated by even more expansive exceptions. So we need to be aware of these kind of classic safety valve provisions to allow more liberalization, but not only look at the liberalization, but also look at the policy space that can be potentially used by governments. So I totally agree with Mr. Bhatia about the political agreements is required when it comes to national security. So for example, whether the authoritative interpretation can be used to reinterpret emergency, I don't know. I mean, it's one of the possibilities. So of course, it can't be used to decide whether it can be self-judging. It's never going to be okay. But whether that can be used for another purpose. Now, I think more importantly is where the government can come together to negotiate or to just more deliberate on what data security is, right? Do we have to have a category of data? Do we have to classify data holders? What kind of risk-based approach we can use? And also, Mr. Bhatia said about whether we're going to still apply the targeting rule to make sure that the instruments targets the source of the risk, or to alleviate concerns about the necessity test, which is more about the instruments. Whether we can think about a country-specific negative list of non-conforming needs as developed in CPT. So all of these things could be potential approaches to think about if there is a potential arising risk in terms of abuse to national security for data industry policy, whether these approaches can be used to strike better balance than the current rules actually provide. As I said, WTO rules are too restrictive. Article 28 might expansive exception. And the current approaches under other free trade agreements went to the other extreme. So I will stop there, and we'll come back to talk about potential policy space. For example, as Gabriel said yesterday about public morals. If there is a public concern about industry policy, developing the IT sector, for example, AI sector, develop the data sector in the domestic jurisdiction, would that be public morals? And even, for example, human rights could be public morals, but a countermeasure against the sanction of human rights because there was a public concern about countermeasures, would that be public morals? Right, so where we are, I don't know, but there are lots of things to think.
Okay. Thanks, Professor Zhou. We now open the floor for the Q&A. We welcome both brief questions and observations. So we don't have questions over here. So this brings this discussion to a close. Let me sincerely thank all the panelists, Ambassador Bhatia, Professor Godbole, Professor Zhou, Professor Zdouc for their valuable insight. Each of you brought immense clarity and depth to today's conversation. I also thank everyone in the audience for your attention, thoughtful engagement. Thank you.
Right. Thanks.
Yeah.
It's not done. Can't do it. So, one. I'm feeling yeah.
Actually, one of the points with it.